looks like, can you see that?
Oh, right.
It's start, yes. Well done. Thanks.
Okay. All right. And my camera doesn't work, but just imagine Brad Pitt. Look, thank you very much for allowing me to speak today. I'd like to thank UNE, Orala, the Myall Creek Armadale Committee, and it's a very difficult thing to follow the two very good speakers that we've had already. What I'm going to talk about today is this idea of laws and frontier violence more generally in some of the work that I've done in North America and in New Zealand. And the way I would like to structure the question is really from a Navajo scholar, Robert A. Williams. And Williams takes the position, which I accept, that law was really crucial to colonialism, and as Ben and Sam have both talked about, and that this notion of law really, one, it was a legal enterprise, but two, it structured the way people viewed European individuals, European colonists and settlers viewed Aboriginal and Indigenous people, and also it allowed them to a mechanism by which to deal with the challenges in the violence that was along the frontier. And so the question, very simply in this little talk, is this proposition by Professor Williams in terms of frontier violence, is it justifiable? Now, when I look at the work I've done in North America and in New Zealand, the comparatives between the various states, and I do comparative law, it becomes pretty manifest. And Australia is sort of comparable, but also outside of the comparison as well. The U.S., Canada, New Zealand, and as well as Australia, of course, are settlement colonies, right? But more specifically, this settlement colony is one part of a global process by which colonization spread across the world. But two, there's a particularly Anglo notion to it, that Anglo legal terms, Anglo economic development and attitudes towards, for instance, economic development permeated all these societies. The second one, of course, is that, and this has already been mentioned, that this notion of the doctrine of discovery and this international law notion of feudal tenure, importing feudal tenures and importing and diminishing the sovereignty of the tribes or dispensing with them is all accepted within these states. Thirdly, in all the states that we're talking about, New Zealand, Canada, and the United States, treaties were used. And the treaties, as Ben has talked about in his presentation, treaties lend a different perspective on some of these legal issues. And the treaties were used to extinguish title, but also to facilitate settlement in the frontier. The next notion that makes these states comparable is that the states themselves, the interaction along the frontier, there was really a set of sort of shared cultural norms that sort of set the tone for interactions. And these cultural norms, these rules of engagement, so to speak, changed as the Europeans and the settlers became more dominant. But this space of collaboration, this space of agreement, continued to impact relations. Thirdly, or fifthly, I should say, the idea of the frontier is very prevalent in all societies, including Australia. And one of the things that's interesting about the frontier is we sort of think of it as a line on a map. And the frontier is really an assertion of jurisdiction. And in many instances, historically, it's been sort of small circles that have extended outward from particular areas. But this idea of frontier and this idea that beyond the frontier, either different law or lawlessness exists versus the colonial law is actually very much part of our thinking. And so it informs a lot of this discussion and legal rules that we have. Sixthly, all these states experience what I call and what others call explosive colonization, where the business of settlement became colonization, that there was so much internal migration, external immigration, economic development, economic exploitation that it actually overwhelmed indigenous people. So, and these were sort of pulses that existed in the history of these countries. So there wasn't a gradual thing. It was sort of a pulse that came through. And then, of course, there was retrenchment. So, and then finally, and I don't have this significantly, the indigenous presence in all these states, including the frontier violence, actually has affected constitutional development. As Sam brought up with the Love versus Commonwealth, these issues many times are constitutional issues at base, and that's something that as we legal researchers and as people involved in this, there is fundamentally a constitutional dimension that that continues to exist. We're not just talking about history; we're talking about something present. So, with that sort of introduction, I'll very quickly go over some of and what I thought for this purpose is we'd look at specific instances because it's not. I think that one, it's easier in the time allowed to be able to talk about, but secondly, the the idea of violence and on the frontier is really can be encapsulated, sadly, in particular instances. So the first example here is the in the United States is the Lakota-Dakota USA War of 1862. And this war continues to impact the upper Midwest in terms of legal disputes and the history of particularly the state of Minnesota. And the Dakota, of course, are known also as the Sioux. And the Sioux, this war grew out of the settlement of Minnesota and the creation of the Minnesota Territory. And so what you had is you had a series of treaties, the Treaty of Traverse des Sioux, which really you could see the area of Minnesota was the area was most of the state of Minnesota was ceded. The area north, the brown area there where the lakes are, that's Chippewa territory. And these, with this provision that right along the Minnesota River there is a stretch of reservation. And the treaty itself and was never implemented on the side of the United States. And as the American Civil War started, there were a series of poor harvests. There was movement away from trade, providing the Sioux with their annuities. And the Sioux in 1862, based on a chance encounter with a few groups in Minnesota, there was a incident. 5 settlers were killed, and under the chief Little Crow, as you can see, the Sioux rose up against the American and the military in the United States. And of course, there were attacks both given by the Sioux across the frontier, as well as retaliatory attacks by the Minnesota militia. And of course, remember, this is during the American Civil War, so most of the troops are in the South. And the gentleman at the top, a man named Ramsey, Governor Ramsey, he is the county in St. Paul where the state of Minnesota is formed, is called Ramsey County. And Ramsey had this to say about the Dakota USA War. He said in September 9, 1862, he said, our course then is plain. The Sioux Indians of Minnesota must be exterminated or driven forever beyond the borders of Minnesota. And in fact, the Union Army came and they defeated the Sioux, and there was the establishment in Minnesota of military commissions. Now, again, these are the same. This is the first time military commissions were set up that became such a product of legal discussion in Guantanamo Bay. So these are the same thing. This is where they started. And the military commissions very hastily assembled in a course of about 3 weeks, sentenced 300 Sioux to hang. This was then sent to President Lincoln. Lincoln, because it was a military commission, had to sign off, and he commuted all the sentences or let people, various individuals go. But in Mankato, Minnesota, 38 Sioux were sentenced to hang, and in fact, this was the largest hanging in the history of the United States, a joint hanging. And the legal basis for these military commissions was basically discussed and then sort of segued into let's do it anyways, which is sort of how military commissions in the United States developed. And of course, these commissions were used throughout the American Civil War and subsequent into Guantanamo Bay. So the rebellion of the Dakota USA Rebellion led to, one, judicial innovation as to how we can bring people within the scope of military law, but secondly, led to the largest mass hanging in the history of the United States. And of course, Little Crow, who started the Native American chief, he was subsequently killed by a settler, and the state of Minnesota paid $500 to the killer of Little Crow. The second event is, of course, in Canada. Canada is sort of prides itself as being not subject to violence along the frontier, and there's a lot of reasons for that. Generally, not the reasons that the Canadians themselves like to subscribe to. But that being said, there's two major rebellions in Canada, and these are the Métis Rebellion and the Cree Rebellion in 1884, 1885. These rebellions were actually independent, but the Canadian government, national government, actually tied them together. The Métis, of course, are an Aboriginal people, a mixture of initial French, mainly French, French explorers who intermarried with Cree and Native American groups in north of the Great Lakes in what was called the Hudson's Bay Territory. And these groups formed a unique culture, and of course, they have constitutional protection in Canada under Section 35(1) of the Constitution Act today. The Cree were Indians that occupied the present-day Alberta, Saskatchewan, and Manitoba. The dispute arose out of two things. One, it arose out of the creation of the province of Manitoba. Manitoba was the Hudson's Bay Territory, and if you go to Canada, you can go to the Bay store, right? And that's the Hudson's Bay Company. And Hudson Bay Company claimed ownership based on a series of grants and a series of purported territorial acquisitions of all the land in the watershed of the Arctic Ocean in Hudson Bay. The Canadian government formed 1837. First Prime Minister of Canada, John A. Macdonald, you'll see in this slide over on the right. They took over the Hudson's Bay Company land because they were actually concerned that at the end of the American Civil War, the Americans might use their big Union armies and go north. The Cree the Canadian government then entered into a set of series, as I've got on this map. The Cree objected to Treaty Number 6. Big Bear, the Cree chief who I have a picture of, objected and said that the treaty was unfair and that the Canadian government, national government, was not going to honor the treaty and diminish the sovereignty of the Cree. And they, through a series of incidents, they took up and rebelled against the Northwest Mounted Police and settlements in current Saskatchewan and Manitoba. The other rebellion was the Métis Rebellion. There's below Big Bear is Louis Riel. Louis Riel was a Métis. He was instrumental in forming the province of Ontario, and I'm sorry, the province of Manitoba in rebellion. He was banished to the United States as Saskatchewan was being increasingly being settled. The Canadian government sent in surveyors, and the Métis, who were based on French law and seigneurial French domain tenure, couldn't defend their property titles in light of the Canadian government, and so they rebelled. And the Métis went to Rael, who had been banished to the United States, and asked him to lead a rebellion or lead the anti-Canadian government rebellion in Saskatchewan, basically do the same thing for the Métis that he had done in Manitoba. There was a series of battles. The Canadian government amassed large troops, declared it a rebellion in the the Battle of Batouche. There you see in that picture 6,000 Canadian regulars with some British troops fought the Métis and defeated them. And subsequently, Louis Riel was put on trial. There's a picture of his trial. John A. Macdonald said Riel must hang. There was issues about Riel's mental competence, and Riel was subsequently executed. And the issue there, of course, is that the Riel execution, he's Catholic, he's French-speaking, and it's impacted Canadian politics, because to this day, the province of Quebec moved from the Conservative Party to the Liberal Party, and now it is firmly in the grasp of the Liberal Party under Trudeau as today. So it had an impact on Canadian development. The final one, very quickly, the New Zealand Land Wars. And the New Zealand Land Wars similarly started with the Kingitunga movement, which resisted the continued sale of land to white settlers, British settlers. And George Grey, who would come back from being the governor of South Australia in his second tour, there's his picture above King Tafiao. He was concerned about the continued frontier settlement, and he felt that the Kingitunga movement, which was asserted sovereignty and Maori law throughout the middle of the North Island, was a danger to settler rule, declared in July 1863 that all Maori need to take an oath to the crown, and in fact, if they don't, their protections under the Treaty of Waitangi will be eliminated. And pursuant to this declaration, he had been building what the Great South Road. If you go to Auckland even today, there's a road called Great South Road. It goes south towards Hamilton, and with the proclamation, the British troops, mainly British troops with colonial legislators, invaded the King Country, invaded Waikato, and there was a series of battles. Subsequently, the Kingitunga movement withdrew from Waikato, and as part of the punishment for the rebellion, the New Zealand legislature passed two acts. They passed the New Zealand Settlements Act, which seized all the land you'll see in the blue lines, inside the blue lines of the map, the North Island, and it continues to be a problem for the new contemporary political and legal problem for the New Zealand government and Maori activists, as well as enacting a rebellion. Let me see the name of it just so I could get the excuse me, I had the Suppression of Rebellion Act, which allowed for a summary detention and execution without judicial review of any Maori who might be in rebellion. And so these three notions, if you look at them, really bring into question the idea that law really structured the frontier and law really determined the course of action along the frontier. Rather, this suggests, even with the presence of treaties, that the legal arrangements that allow for the extension of law and the extension of colonial rule was sort of I don't know if anybody's heard of it, there's like a Rube Goldberg device where you make things fit to justify an underlying political, economic, or legal objective, and that the rule of law in all these instances, the protection of the law, nor the idea that the indigenous groups had a claim that could be cognizable under law was not considered. And so in two of these instances, of course, also in Canada, the Cree Rebellion led to the largest mass hanging in Canada of 9 people. So these extension of violence through the use of violence is really, the law is used as a justification to cover up the essentially lawless acts of frontier expansion. On the other hand, as far as how the world is structured in the eyes of lawyers and settlers, and to the extent also indigenous people, the law allowed them to see the world and see the opposing forces in a way that's understandable. So this idea of looking at the world and claiming legal rights and claiming rights under different legal systems and understanding indigenous folks is part of the operation of law. So it had a social function as well as a legal function. And then the final thing is all this mean that law is unimportant for indigenous people today? The answer would be no, that this law provides opportunities for people to effectuate their rights as well as solve some of these historical injustices. And so that's all I have to say, and I apologize for going over time.
Thank you very much for that, Brad. I mean, Guy, that was excellent. And I certainly enjoyed the vision of Brad Pitt throughout your presentation as well.
Yes.
So we've got time for perhaps 1 to 2 questions if anyone has any for Guy. Okay, we've got one here. Thank you very much, Guy. My name's Catherine. I just wondered if you could tell us again what the name of that, you said the concept where you make things fit according to the political objective. Can you just say what that is called again?
There's when my son was younger, we used to make these little devices that would have like balls running, and they'd go down a track, and then they would jump and hit another domino set. And they're called Rube Goldberg devices. They create, through a meandering series of various haphazard actions, that creates an outcome. There's a British BBC show called Professor T. I think it starts with a Rube Goldberg device, and the idea is you take various legal doctrines, you take various laws, you take various practices, and you sort of batten them down together, and you create the legal outcome and political outcome that you want, and then subsequently that becomes law. So that's the idea.
It sounds like there's going to be a new associate professor, Guy Charlton,
legal doctrine relating to that principle. That was excellent. Thank you.